Hello and welcome back to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to a case out of New Jersey. This is Sean Higgins. He is accused of striking and taking out one NHL hockey player, one National Hockey League player, and the other one, his brother, the Gaudreau brothers. So settle in, get comfortable, and let's get started. All right, welcome in, everybody. Welcome in. Thank you for joining us. Iowa Backyard Cam member for 12 months. Thank you so much for that. Appreciate that so much. Let's see, who is with us? We have Aussie Gardner and Horse Welfare. Grampy, good to see you again. Gina, thank you for joining us. William and Mal, see you in a couple hours. Yep, we are live now. Good vibes only. William, good to see you again. YT Hazel says, keeping tabs on this one. I watched a lot of Johnny when he played for the Flames. This defendant needs to be held accountable. Camilla is back, but going out to lunch. You need some love chat? All right. Hopefully you'll find some here. Anthony, what is it all about? We will explain that in a minute. We do have a playlist. I dropped a playlist before we went live. So we've been covering this for a while, since about a year now, over a year. Michael, both brothers played hockey, one for the NHL, would have been on the Olympic team. Debbie, good to see you. Itty Bitty, good to see you. Let's see, who else? We got Kimbers, we got Christy, Aussie Gardner, Richard in the kitchen. It is puck drop time. Absolutely. Jenny G, good to see you. All right, I think I got everybody. Let me just scroll up here in case I didn't miss anybody. Heidi, good to see you. Downey Lynn, Beach Mom. Glee Roll, good afternoon, you are back. Hell yeah, how are you doing? Bama Green Eyes, Toots, good to see you. All right, I think I got everybody. Crystal, hello, yes, you. Hey, Margaret, you made it. You are here. Awesome. All right, I think I got everybody. If I missed you, I apologize, but I think I got everybody. All right, so let's get comfortable. Let's settle in. All right, the date of this incident is August 29th of 2024. So Sean Higgins is the defendant. He is 46 years old. You have Johnny and Matthew Gaudreau. So you've got Johnny's 31, and Matthew is 29. They were in New Jersey, celebrating their sister's wedding. So let me read through this. So August 29th, and we've done about 10 hearings so far. So I'm going to show some news. I'm not going to show as much as we have in the past. So I would encourage you, if you really want to know, go back and look at our playlist. But I'll do enough that if you're fresh to this case, you'll have an understanding of what's going on. I won't do as deep of a dive as we've done on other streams, but at least you'll get an understanding of what's behind this. So August 29th, 2024, NHL forward Johnny Gaudreau, 31, and his brother Matthew were struck and killed while riding bicycles northbound on County Road 551 in Oldsman Township, New Jersey. The brothers were in town for their sister's wedding scheduled for the following day. So it's like, Labor Day weekend, something like that. And they're in town and they're celebrating and they're on bicycles. Keep that in mind. And this was at night. It wasn't like, I think it was like 8 o'clock or something like that. But I I don't know if, 819. Let me just continue reading. Prosecutors allege that Sean Higgins was driving a Jeep Grand Cherokee northbound behind two vehicles when he attempted to pass. According to court documents, an SUV ahead of him moved towards the center of the roadway to safely pass the cyclist. So that person saw the brothers. Investigators say Higgins believed traffic was moving too slowly. He entered the southbound lane and ultimately attempted to pass on the left shoulder before striking the Gaudreau brothers from behind at approximately 8:19. Now I have this. This will kind of give you a better understanding. So he's been drinking. Higgins has been drinking all day. They found cans of beer in his car. So Sean is number one. He's on the bottom, right? So he's and eyewitnesses in these cars are saying he came up really aggressive. He was tailgating them. He was being an aggressive driver. So he's driving. He tries to pull around he's trying to pass both of them, but the lead car pulls out to avoid hitting the brothers, and Sean thinks that person's being a jerk and trying to cut him off. So he pulls into the regular lane, and unfortunately he strikes the brothers. So responding officers reported that Higgins' breath smelled of alcohol. He allegedly admitted to drinking 5 to 6 beers prior to driving and later registered a blood alcohol concentration of 0.087, slightly above New Jersey's 0.08 legal limit. Authorities also state he failed field sobriety testing at the scene. Now, this is very important because the hearing we're going to watch today, we're going to watch two hearings. One is from just a couple days ago, I think the 11th, and then the other one is from February that led into this one. So we're going to watch two hearings today along with a little bit of news just to kind of give you a backstory. But the one that was from the 11th is very important, so keep that in mind. He had a blood alcohol level of 0.087. The defense is arguing that the brothers had higher alcohol levels, which they did, and so Sean shouldn't be held accountable or something to that effect. Let me find. I thought that I had it. So the brothers' alcohol level was Johnny's was 0.129 and Matthew was 0.134. So the brothers were like, let's see, 0.08, like two. What's that? 2 times would be 1.6. So they were right. Am I doing my math right? If it's 0.08 to 0.12, their double would be 0.6. So they were well over the legal limit. So the defense is kind of arguing, well, they were drunk. They were more drunk than my client, so my client should be held not responsible. That's kind of what part of their argument is. Believe it or not, that's kind of one of their arguments. So he did plead not guilty. However, he was offered a plea deal. He was offered a plea deal of 35 years and he turned it down. Right? So he now faces 70 years. So basically 35 years for both the brothers. But he rejected a plea deal. So throughout 2025, the defense challenged the admissibility of Higgins' statements, arguing he was not properly advised of his Miranda rights. In November of 2025, the trial court ruled the statements were lawfully obtained. January 15th of 2026, a New Jersey appellate judge upheld that ruling, meaning Higgins' admissions, including statements about drinking and striking the cyclists, may be presented at trial. And as early as this year, or as of early 2026, thank you. As of early 2026, Higgins remains in custody pending trial. Case is moving through the final pretrial litigation before trial date is. So, excuse me. Banty, you live where Higgins lived. Awesome. Okay. A mom lost 2 sons. Yeah, the same. Yep, exactly. All right. So that's a little backstory. Let's come over here. Don't need the disclaimer again. All right. So again, I'm not going to show all of the news clips. I'm just going to show a few just in case you're not familiar with this. And then we'll get to the 2 newest hearings. So I'm just going to show We're just going to show a few news clips, and then we'll get into the hearings from February and then earlier last week.
A court appearance today for the man accused of driving under the influence and killing an NHL star and his brother. 43-year-old Sean Higgins was denied bail.
Police say Higgins crashed into Johnny Gaudreau and his brother Matthew while they were riding their bikes late last month. Tonight, we're learning new details about Higgins.
Friday night, the big story on Action News is the suspect charged in the deaths of the Gaudreau brothers held without bond.
Today in court, prosecutors described a history of alleged road rage and aggressive driving. Action News reporter Charles Watson live in Sewell with those details tonight. Charles.
Yeah, Rick and Shari, folks we spoke to say the deaths of the Gaudreau brothers is still fresh and painful as they get ready to celebrate the two brothers tonight at their hometown ice rink. Meantime, we're learning that the suspected drunk driver accused of hitting the two brothers may have a history of road rage.
As the story unfolds, it just gets, worse and worse.
As the community continues to grieve the loss of NHL star Johnny Gaudreau and his brother Matthew at this growing memorial, the alleged drunk driver prosecutors say is responsible for their tragic deaths will remain behind bars without bond. A judge making the call today at a virtual hearing that revealed suspected drunk driver Sean Higgins allegedly admitted to police that he had been drinking while driving prior to the fatal crash that killed the Gaudreau brothers.
We are dealing with a driving pattern and action on the night of that was sheerly a matter of impatience, anger, and recklessness.
Prosecutors argue that Higgins has a history of road rage, pointing to a witness accounts that allege the suspect sped around their vehicles before fatally striking the brothers.
He is simply impatient and angry at the speed of the two vehicles that are in front of him. He has been drinking.
Attorneys for Higgins argued that he was barely over the legal limit and later described him as a law-abiding citizen.
He's not a flight risk, Judge. Prior to this incident, he'd be what we would call a model citizen.
Attorneys for Higgins argued that he was barely over the legal limit, but that argument wasn't enough to win the judge over. Outside the hockey rink where the Gaudreau brothers will be celebrated tonight, folks who knew and admired the two, like Scott Shelton, couldn't help but talk about how special Johnny and Matthew were.
It's very surreal. He's in the All-Star game 2 years ago, and you hear the story.
Coach Matty just took time out to talk, and we had a good time.
This as they still try to wrap their heads around the unfortunate circumstances that stripped them away from everyone.
You took two good lives, and for what?
Yeah, and you can see the growing memorial behind me full of hockey sticks, photos, flowers, and Skittles. We're told that was a favorite of Johnny. We're also told the Gaudreau family will be in attendance tonight for this celebration. And, of course, Johnny and Matthew's two wives who, of course, are pregnant. We're live tonight in Sewell. Charles Watson, Channel 6, Action News. Sharp.
Now, I'm pretty sure at the Olympics they did a little tribute to them, right? If I'm not mistaken, I remember this past Winter Olympics. They did I think, was it before the gold medal between Canada and the U.S.? I'm pretty sure they did a tribute. For those that watched it, I'm almost positive they did. So basically, drunk driver, Sean Higgins, driving drunk. They say he's a model citizen. Well, he's a field artillery officer. He was assigned to the New Jersey Army National Guard. He's a part-time traditional drill status guardsman. He was not on duty at the time. He also, now here's the thing, they had their jerseys. Yeah, okay, that's what I thought. Beach Mom and Missy, they did afterwards too. Yeah. I should give 8-Ball his stern talking to. All right, I'm sure. I'll get to that in a second. And the kids came out on the ice. Yeah, I remember all that. I do remember that. Yeah, that was so sad. Just absolutely sad. Yeah, USA team honored their brothers. Their children were there. Yeah, I think so too. Yeah, I kind of remember that. And then the U.S. won the gold. Yeah. So, all right. Oh, yes. And after the gold medal game, at the time of the team picture, they brought out his jersey, had a picture taken with teammates holding it. They gave the wife the jersey. Okay. Thank you, Michael. Yeah. I remember I didn't watch it live, but I saw I was coming in and out and I watched little clips of it. And then I saw the news on it too. So Again, just terribly, terribly sad, terribly sad. And I don't know, he's saying his defense is saying, Higgins is a model citizen. Yeah, that may be very well, but you were drinking and you hit 2 people and they're no longer here. Even if you weren't drinking, you still hit 2 people. Here's the kicker, though. Higgins worked for a rehab facility called Gaudenzia, Gaudenzia, Gaudenzia. Interesting, right? All right, I'm going to play just a few more little clips, and then we'll get into the hearings that we have not watched yet. So again, I just kind of want to give you, in case you're not familiar with this case, we'll just give you a little.
You're charged now with.
We'll give you a little taster because we've done deep dives on this and we've shown these before, but I just want to give you, just in case you're not familiar with the case, just show you a little bit.
You're charged now with 2 counts of second-degree vehicular homicide. Both of those charges are punishable by a maximum 10 years in New Jersey State Prison. Do you understand that those are the charges to bring you before this court and those are the potential penalties that you face?
Yes, Your Honor.
At today's hearing, you do have certain rights. Among those rights are the right to be present, and you are in fact present here today in the virtual courtroom. You also have a right to be represented by an attorney, and today you're represented by Mr. Dooley. You additionally have a right to remain silent. Keep in mind anything you say here today may be used against you. Note that while Mr. Dooley is your attorney for today's proceeding, he may or may not be the attorney assigned to represent you as your case proceeds through the court system if you are ultimately still represented by the public defender's office. Have you given any thought at all at this time as to whether you want to continue to be represented by the public defender's office or whether you'll be hiring your own attorney?
We'll be hiring my own attorney in the future, Your Honor.
With the holiday, I believe that takes us to next Thursday, September 5th for the detention hearing.
That is correct. So, Mr. Higgins, your detention hearing is going to come back before this court on September the 5th. You'll be brought back to court for a hearing on that day. In the meantime, between now and your court date on Thursday, the state must turn over to your attorney discovery. That's any and all reports or documents in the state's possession which are relevant to their application to detain you, as well as any and all exculpatory evidence must be turned over to your attorney between now and the hearing on the 5th.
So when I actually do hire an attorney or get an attorney, obviously I have very limited contact with anyone now. I don't have a phone. I can't really reach anybody. How do I get that process started with them?
So, Mr. Higgins, if you're interested in hiring counsel, you need to speak to somebody at the jail, and they can help you facilitate contacting people. If you have family or friends on the outside who are willing to assist you in doing that, you may be able to reach out to them in order to get that done, okay?
Understood.
Right. At this time, we're going to excuse you from court today. We'll see you back in court on Thursday.
So I'm here until Thursday?
Yes, sir. Yeah, once the state files a motion for your pretrial detention, the statutes and court rules require me to hold you over for a minimum 72 hours before your hearing. Because we have a weekend and we have a Monday holiday, 72 hours becomes Thursday. Any other questions?
Not this time, Your Honor.
All right.
All right, he did not like that, being held over. So, all right, Aaron found this, so this is great. Thank you again, Aaron, for finding this.
It was a memorable...
Aaron found this.
It was a memorable finish for Team USA in many ways. And while we wait for Zach Werenski to rejoin the team this week with his gold medal in hand, I spoke with another person in the Blue Jackets organization who is a part of the exclusive fraternity to win a gold medal.
You know, it's something that sticks with you for the rest of your life. It's not, you're not only an Olympian, you're an Olympic gold medalist. And, you know, that's almost bigger than sport.
Now shoots, he scores! Blue Jackets Director of Player Personnel, Rick Nash, understands how it feels to win a gold medal. The former CBJ forward won 2 with Team Canada in 2010 and 2014.
It's just a moment that you kind of dreamed about your whole life, and you can only really relate it to winning a Stanley Cup in the hockey world.
On Sunday, when Team USA beat Canada 2-1 in overtime to win its first gold medal in 46 years, Nash wasn't rooting for a particular team. Instead, he was rooting for one person.
I was watching as a complete fan, which was really exciting, but but I was obviously pulling for Zach.
Blue Jackets defenseman Zach Werenski helped create a memorable finish for Team USA when he set up Jack Hughes for the game-winning goal.
He's such a big part of our organization and a big part of our city that, for him to get the primary assist on the game-winning goal, it was so special, and I'm so happy for him and his family.
Z lived out his Olympic dream, and after the game, he and his American teammates helped a player enshrined in Union Blue live out his.
We got wind of the idea in the office. I was almost brought to tears right away to think of, Meredith and the kids going over and his parents going over to, obviously something that Johnny would have been at.
While Johnny Gaudreau would have been in this photo if he were still alive, the best parts of him were captured in America's golden victory.
It was kind of a heartbreaking moment, but at the same time, like such a proud moment to be able to get to know that family and, to get to know Johnny and what kind of person he was. And now you can really tell the kind of legacy that he left on the Blue Jackets, USA hockey. We miss him every day, and people obviously still care about him very greatly.
Werenski became the first Blue Jackets player to win a gold medal for the United States and second CBJ player to win one, joining Rick Nash. Also, Z's 6 points in the tournament are the most by a CBJ player in the Olympic Games. The Blue Jackets resume play on the road against the Bruins this Thursday at 7 p.m.
Thank you for watching the ABC6 News YouTube channel.
Well, that's definitely very, very, very moving, very moving. Debbie, thank you for the 5 Trial TV Live gifted memberships. Appreciate that. Missy, yep, glad you're at home to tear up. That was sad. Do I have my hockey jersey close by? I do not. I do not. So, all right. So that's very, very emotional. All right, let's watch. Here, his lawyers want his charges to be dismissed. So we'll watch this, and then we'll continue on. You know what? Hold on a sec. We'll come back. Let me see. I have to make sure we're doing a stream with Claire at 4. I just have to make sure I end in time. So this is 20 minutes. This is 40 minutes, so that's an hour. That'll get us to 3:30. Okay, I do have time. All right, I have time to show this. Let's show this, and then we'll go into that.
All right, Council, let's proceed next with the matter of State of New Jersey versus Sean Higgins under indictment 2412-405. And we'll have to bring Mr. Higgins out.
Good afternoon, Your Honor. Michael Mestern appearing on behalf of the state.
Afternoon, Your Honor. Richard F. Kleinberger III from the firm of Kleinberger and Nussey, appearing on behalf of defendant Sean Higgins, along with co-counsel.
Judge, thank you. Good afternoon. For the record, it's Matthew Portello on behalf of Mr. Higgins, along with Mr. Kleinberger as co-counsel.
Thank you. Good afternoon, Council. We're here for an initial case disposition conference. Council, it's my understanding I received earlier today several motions that were filed at this time by the defense, and my intent is to do scheduling orders for briefing if defense is going to be filing briefs as well as reply time for the state. So under the circumstances, you file the applications. I'll ask you how long it will take to provide any necessary briefs.
With regard to the dismissal motion, part of what we need besides the scheduling order is throughout the grand jury transcript, the state makes references to photographs and exhibits. They're not attached to the grand jury notes. So I would need those first before I prepare. So I need, if, for example, if they say exhibit 1, I would need the photo or the diagram marked as exhibit 1 that was utilized at the grand jury. If it was in color, I would need a color photo of that as well.
Judge, I'm going to follow up with Mr. Mestern requesting that information.
Mr. Mestern, do you have those documents in your possession at some point you can turn them over to me?
I do, Your Honor. Yeah, I can have them to him before the end of the week.
Wonderful.
I would ask that I get a copy of the grand jury transcript as well to kind of go through what was or wasn't. It was a few months ago, so I don't know exactly which. But I do have the photos. Just want to make sure I have the right things that I'm handing over.
Sure. So if council can turn over the copy of the transcript to Mr. Messner with the understanding that you'll identify the documents and the photographs or diagrams that you're looking for. Yes, Mr. Klein.
There's a little concern. So exhibits are marked. And when exhibits are marked to grand jury, they're reserved, correct?
They should be.
Okay. So when he said he wasn't sure what he showed or not, I got a little concerned for a minute there that this was not going to be a recreation of the record.
It isn't, Your Honor.
Okay.
I have multiple
Just making sure.
photos, and I don't think I used every one in the presentment.
Understood. So there may have been several photographs that he had prepared for the presentation, but only used certain photographs.
Just so we're clear, I want the ones that were
actually
marked and used. Yes. And
again, I need the information. So you'll transcript.
I'm going to email the transcript either this afternoon or first thing tomorrow morning.
Perfect. And once you get the transcript, you can review it and then provide the necessary exhibits.
And then if I could get a letter specifically detailing which ones as well.
Oh, it's in the notice.
All the exhibits that are identified in the grand jury transcript are the exhibits being sought by the defense.
Correct. That's in the notice.
Did you receive the notice of motion?
It was e-filed this morning.
Yeah, about 9:30, 11 o'clock this morning.
So obviously, Mr. Messer, he's been poor all morning, so I'll take an opportunity to review it. But if you want to just follow up with a detailed letter, exactly what you're looking for, I'm sure Mr. Messer will be happy to turn it over.
Just everything. So
understood. So at that point, are you prepared to proceed, at least at this point, with briefing schedules for the motion? I know you're seeking some discovery regarding other related type of plea offers.
Correct, John.
So are you prepared to proceed on that? At least for briefing?
Yeah.
How long will you need to file a briefing?
3 weeks.
Let's take a look at the calendar. 3 weeks takes us to the 25th, I believe. So what we'll do is defense brief, we do 225. And that is the brief regarding prior plea offers by the state. And Mr. Mestern, how long do you need to respond to that?
I'll need 3 weeks as well.
Absolutely. So that takes us then to 318 for the response. And Mr. Feinberger and or Mr. Portella, obviously we won't schedule anything on the motion to dismiss unless and until you get everything that you need. And then once you get those documents, I can do a briefing schedule for that. Unless you want to do a briefing schedule.
Can we do it today, Judge?
That way we know if we get everything by Friday. If there's an issue, we'll contact the court.
Sure. Do you want to use that same 3 weeks?
That works for me.
That works.
And Mr. Mestern, same 3 weeks?
It's fine, Your Honor.
All right. Do you want to just say then all the motions that were filed are going to be on that same schedule, 3 weeks?
Sure.
For the state, 3 weeks for the defense?
Sure. That works.
The one regarding the blood, Your Honor, I don't think we need an actual motion. I do believe the blood request is proper.
Chain of custody?
It was more than that. It was chain of custody, refrigeration records, everything. If there's something the state objects to that, they can let us know. But everything that I asked for is standard in any other blood case I've had in New Jersey.
So in essence, it's not a motion, it's a discovery request.
Right. But we requested discovery initially. Certain things were missing, which is why I filed like this to preserve any issues that may occur.
Understood.
And I'll reach out to the lab and let them know what the request is, and then and they'll provide me with whatever it is they have.
Yeah, I mean, under the circumstances, you should be able to establish and provide them with chain of custody.
It's not really chain of custody. It's more, for lack of a better term, chain type documents for blood draws.
Understood. And Mr. Kleinberger, if you receive all that, there'll be no need to argue that.
Correct.
Any other issues that you would like to discuss today?
Judge, I just can inquire of the state because we've received about 17 separate packets of discovery from the state, and it didn't look like everything was complete. We just want to make sure that the state has anything else that they are intending to turn over, that we get that rather quickly, Judge.
Thank you, Mr. Messner. Is there anything else that you have in your possession that you feel obviously you need to turn over to the defense?
Your Honor, over the last 2 weeks, I did send over various documents and media in the case. And so as far as the state's concerned, everything discovery-wise on the state's end has been turned over. State's ready to proceed at this time.
Thank you. Is there any reciprocal discovery that you gentlemen need to turn over to the state?
Not yet. So does the state have any expert? Do you have any expert reports or any expert?
The state police reports that was discovered, it's sent out and discovered.
That's it?
What the state has. Right?
Okay. And is there a blood draw expert?
The chemist that did the blood draw analysis is who we would call.
Okay. Once we go through everything.
And then if defense has an expert, obviously we'll take a look at that. And if we need to refute their expert, then we would get an expert.
Sure.
Okay.
Reasonable.
Yes.
So let's do this. All the filings are due no later than March 18th. We'll need to bring it back hearing date sometime thereafter. And I would like to do it on a day that we don't have a full list calendar, in case things do get a little lengthy. Counsel, what do your schedules look like at this time on March the 26th?
I'm available, Your Honor.
It's open that day, Judge. I'm open.
We should have availability of voting, that's correct. All right, let's schedule it. Let's bring it back March the 26th. It's an off day, so this that day. And we will schedule it for 9 a.m. on the 26th of March. And I suspect it'll be in this courtroom, but it could be in one of the other courtrooms on the other side of the room. Yeah, but we'll notify you as to which courtroom it is as we get.
And Judge, that's listed as the FCDC and the motion argument.
That will be FCDC as well as motions.
And Judge, as far as excludable time is concerned, up to 2A162, I'm assuming we're just leaving everything now because there's no set discovery end date.
Well, at this point in time, there are motions filed. So because the defense motions filed, theoretically, we looking at excludable time.
Okay.
And I obviously was going to ask for excludable time.
So we're going to bring it back, as I indicated, on Wednesday, 3/26 for the motions, as well as FCDC. Any and all time between today's date and that date will be excludable.
Let me scan that. I'll send it to you.
Anything further, counsel?
No, Judge. No, that's it, Judge. Thank you.
No, Your Honor.
Thank you.
Yes. And Judge will receive the scheduling order.
Absolutely. My law firm will make sure that gets out to you.
Sounds good.
Thanks, Judge.
Thanks, Judge.
All right. So now I want to watch one from February. They actually had one. Hold on a sec. This was via Zoom. So this one we have not watched yet. This is one that I haven't personally watched yet. So the next two ones we're going to show you, we have not watched here on Trial TV Live.
All right, looks like we. All right, looks like we have everyone in the room. Just want to make sure. Looks like we do. All right, perfect. Good afternoon, ladies and gentlemen. We are going to go on the record now in the matter of State of New Jersey versus Sean Higgins, coming to the court under indictment 2412. 400I. Counsel, please enter your appearances.
Good afternoon, Your Honor. Michael Mestrin appearing on behalf of the state.
Good afternoon, Your Honor. Richard F. Kleinberger III appearing on behalf of defendant Sean Higgins along with co-counsel.
Good afternoon, Judge. For the record, it's Matthew Portello on behalf of Mr. Higgins along with Mr. Kleinberger. And for the record, Judge Yannick Cools, my associates online with us as well.
Good afternoon, Judge.
Good afternoon. All right. Thank you, counsel. Just housekeeping purposes for the record, I appreciate you all being able to join us by way of a Zoom link today. Obviously, we were scheduled for an in-court appearance at 1:30 this afternoon. However, due to the Chief Justice closing the physical courts again due to the snowstorm that hit yesterday, we had to move this to a remote proceeding. I know, counsel, we spoke briefly, defense counsel as well as the prosecutor the other day in an in-camera conference, but can you enlighten the court as to where we stand now? I guess I'll go to the defense first, and either Mr. Kleinberger or Mr. Portella can respond. Based upon our last conversation, it was my understanding the defense is now in possession of its expert reports. Is that correct?
One of them, Your Honor. The toxicology report has been turned over to the state with regard to the issue with the draw and testing. It seems that it was plasma that was tested, not whole blood. Based upon our expert report, that brings the actual BAC reading down to a 0.075. With regard to the accident reconstruction report, the only thing that's needed, Judge, I was going to send, was placed on the record today, and I'll send a letter following up regarding same, is the discovery that's been received by the state. They did send us all of the documentation regarding the infotainment center with the download. However, in order to do a proper evaluation and examination, we need a download of the actual, and I'll send this to the state, but it's a .ive file or raw data directly onto a USB flash drive. If we try to do what we have done in the past, downloading it through the portal, it doesn't work when they go to run it through. So I need the state police to actually place it onto a flash drive, the raw data, in the form of an IVE file, and forward that. Everything else is done regarding the accident reconstruction as opposed to that. And Judge, there has been based upon the reading of the BAC being done by way of the plasma, there has been a notice of motion to dismiss for this to be represented to the grand jury with regard to that. That motion was filed yesterday.
Judge, if I may, for the record, it's Mr. Portella, or Matt Portella. Judge, I just want to confirm with Mr. Higgins that he can hear us and see us because a guard just walked into the booth. Judge, can we just inquire of Mr. Higgins?
Okay. Can you hear me?
Yeah, we can hear you, Sean. Can you hear us?
Yes, sir.
So I can't see you. It's just a black screen. I didn't know if I was on.
No, you're in. Can you hear us, Phil?
I can hear you. Yep.
All right, perfect. Thanks, Sean. Sorry, Judge.
Thanks. So, Mr. Higgins, we can hear and see you, sir.
Okay.
So, Mr. Kleinberger, you're indicating to the court that a recent motion to dismiss the entire indictment or just certain counts of the indictment?
Judge, at first it was going to be, it's funny you say that, it was going to be just for the counts regarding, but the issue comes with it, and upon retrospect, I filed it for the entire indictment based upon this. If the grand jury heard that the reading was a .087, and when in actuality that was done based upon the plasma, and I mean, this is science. This isn't something that's speculative. There's a mathematical formula that's utilized for this, and the actual reading is a .075. Therefore, we don't know how much that impacted the jury when it came to the grand jury when it came to other aspects of the case. Was this guy so drunk that he did this? It taints it. For this, to err on the side of caution, I filed it as a total motion to dismiss, but it might not apply to everything, Judge.
So, Mr. Mestern, have you received a copy of this report?
I received it late on Thursday. I was in court all day on Friday, in court yesterday, so I've seen it. I haven't really delved too deep into it, but I will be reaching out to those that did the analysis of the blood to get their opinions on it.
And thank you, Mr. Mester. And if you'll refresh the court's recollection, when this matter was presented to the grand jury, I do recall BAC levels being presented. Is that accurate?
Yes.
All right. So assuming for the purposes of argument's sake that Mr. Kleinberger's expert and his analysis is accurate, would this be something that the state would be looking to represent?
If it's accurate, but I'm not conceding that point.
I said assuming. I didn't say it was. All right. So
it wouldn't touch upon the entire indictment.
No. But as to particular counts, it may.
Maybe.
So what I'm going to suggest, counsel, is that I'm not going to ask you to file briefs or anything at all at this time regarding your motion. We're going to hold the motion in abeyance. Mr. Mester, and I'll give you an opportunity to discuss this with any state police experts that you believe are appropriate to review the blood draw, or any outside experts you believe are appropriate to review, I should say, the blood or plasma analysis. If you come to the determination that based upon the information presented, that it's appropriate to represent the matter to the grand jury with the BAC as reflected in the defense expert report, the court will allow that to happen. If you decide that it's something that you're not interested in doing, obviously then I'll schedule a briefing schedule asking the defendants to file briefs, and then you can respond to their brief. Does that sound reasonable?
It does, Your Honor. I think it would be more prudent to do the briefing schedule now, and then if I do the analysis and decide to represent it, I can let the court know and defense counsel know, and that would void any kind of briefing necessary. But just to get the ball rolling on that, it might be more prudent to do it that way.
Yeah, well, my only concern was, obviously, if we could avoid creating more work and having more additional briefs filed, if your office is going to merely represent the matter, I'd rather hold off on those briefs. So I'm going to hold that Mr. Kleinberger, Mr. Portello's motion in abeyance at this time. I'm not going to ask that they file any briefs, but I am going to ask that if we can get a quick turnaround from your office's position with regard to the defense expert, that would be helpful.
Very well, Your Honor.
Now to the next issue that we briefly talked about, and we've been talking about for the last year plus. Has the defense proffered a counteroffer? And I'm not asking you to place it on the record at this point, but have you actually presented a counteroffer to the state at this time?
Judge, we have presented the counteroffer. We'll put it in writing, sent it to Mr. Mester. We emailed it this morning, Judge, and we won't put the terms on the record, Judge, but we did include the extensive research that we did for other cases that are similar factually to Mr. Higgins's matter, and the results that came about by virtue of plea bargaining with the state, Judge. And that is a 4-page letter that has that information in it for the state to keep in mind, and to frame it in terms of our counteroffer, what the state has done and what offers it has given to similarly situated defendants on their cases in the past.
All right, thank you, Mr. Portello. Mr. Mester, you are in possession of that document?
I am, Your Honor.
And obviously, I would ask that we discuss this further with the understanding that given the fact that now the defense has actually provided a counteroffer, which had not existed up until this point, it may also obviate the need to either represent the matter or litigate the motion. So I'll leave that to counsel to discuss between themselves. If the counsel feels as though the court needs to engage or involve itself in plea negotiations, obviously the court would be happy to entertain that, but I'll leave those discussions to happen between yourselves. Okay, counsel?
Thanks, Judge.
Judge, just could we get an idea as to turnaround for that the download? Like I said, the state did provide the I guess it's the text data, the way it downloads to the portal. You can't utilize that for running a test. So, for example, in a colloquial term, I would view it as it's like looking at a strand of code. So, they could attempt to recreate it, but it's not going to be accurate in order for them to say that it was the exact copy. So all we need is and I'll send it to the state as soon as we're off, but it's the exact copy of the raw data or it's called an IVE file.
Mr. Mester, are you familiar with that?
I believe there was a thumb drive sent out in the initial discovery or sometime thereafter. But if I can get a letter with the specifics from counsel, and that way I can submit it to the state to police to see, it's a technical aspect that is outside the realm of my expertise. And so I'll reach out to the state police for them to take a look at the request.
All right, Mr. Kleinberger, you'll follow up in writing then.
As soon as we're done, Judge, I have it waiting here. I just want to place it on the record first before I send it out. That's all.
All right, yeah, it sounds like a technical issue. Obviously, I don't expect Mr. Mester to be completely familiar with that. So once he speaks to the parties at the state police who may have further knowledge in that area, if they can provide that, I'm sure he will absolutely get that for you and turn it over as it is discoverable. So, counsel, other than what we've discussed, is there any other issue that any of the parties would like to address at this point?
No, Judge.
No, Judge. Thank you.
All right. So this was listed for a discretionary conference today. I'm inclined to move it to the pretrial conference list as we've had significant movement at this point with regard to counteroffer as well as expert reports at least being available regarding the blood draw and soon to be available regarding the accident reconstruction. I'll just ask counsel, how long do you think you're going to want to have before we bring it back for our first PTC? I'll start with the defense.
It depends, Judge, on the motion to dismiss. What's going on with that?
And how quickly you can get the additional discovery from the state police if they're going to turn it over.
Right, which is going to take some time, I would suspect, Mr. Mester.
Well, Your Honor, with the motion to dismiss, hopefully we'll have an answer to counsel and Your Honor within a week with regards to the information, the technical information. I'm not too sure, maybe a week and a half, 2 weeks for that. I'm not too sure if their defense expert, is going to need time to digest and do a report. It seems like he hasn't really done much with the data that was provided. So
we have a report done already, Judge. That's the last piece needed. We utilize the everything else that was there on scene. So we have a report done. This is the only piece that's missing. My expert did not feel comfortable putting forth the report unless they can compare the data that was received from the state in the form of the copy of the download to an actual download. That's it. That's the last thing. So once we have that, that's it. But I could tell the court that there is issues, factual issues that will be brought up already, but we just want to make sure that the T's are crossed and the I's are dotted here.
Understood, Mr. Kleinberger. So I suspect a return date or bringing it back on March 10th would be premature, probably a little too soon.
Probably too early,
yeah, Judge. And I'm not available that day either. Yeah.
Okay, give me a moment.
Judge, would this be for a status type date to see where we are with regard to the state representing or not and the discovery?
So we're actually going to move it to a pretrial conference. Right. With regard to all those other things, they should occur between today's date and the next date. I don't see any reason why things cannot get done between counsel. If things need to be addressed sometime with the court, you can just reach out to the court, and I'd be happy to conduct, an in-camera conference at that point. But I'm looking at now a return date if everything works out with council schedules of April the 7th.
I am available that day, Judge.
Judge, could we do 1:30 on that day?
We can absolutely do one.
No, I'm not available that day.
Oh, sorry, Mr. Mestern, you're not available. All right, let's take a look then at some other dates. How about in the PM on Friday the 10th?
That whole week I'm out.
Oh, you're out that whole week?
That's my birthday, Judge. But I'm out.
We don't want to disrupt your birthday, Mr. Portella.
Yeah, I'll be out.
All right, let's look at then Tuesday the 14th.
That works, Judge.
1:30?
I have jury duty. If I get
you have jury duty
collected, but
well, the question is whether you even get called in for jury duty.
Yeah,
and I'm sure if you let the court know that you have a scheduled mandatory court appearance on that date, that they would excuse you for that day.
Judge, I'll call jury management on that. Good excuse to get out of it, right?
Well, I mean, we're not looking to get you an excuse to get out of it, but on that particular day,
just that day,
I'm sure they can reschedule you for another day, Mr. Portella.
I'll take care of that today, Judge.
So we go for 4/14 at 1:30 p.m. And Mr. Mestern, that works for you?
That should work for me. I have a trial scheduled for that week, but I'll once we get closer, I'll have a better idea as to whether.
Yeah, I mean that's a month and a half from now, so we don't. You never know what's going to happen between now and then. So at this point, we'll go for 4/14 at 1:30 for the first pretrial conference.
And just for the record, it's in person, obviously, yes.
It will be in person at 1:30. And counsel, please keep me apprised if you need anything. If there's going to be a decision by the state to represent, obviously let the court know and continue to let the court know if there are any discovery issues. Mr. Kleinberger, if you'll alert the court once you receive that technical information that you're looking for, this way the court's aware that you have it.
Thank you, Judge.
Thank you. And then obviously alert the court as to when you provide Mr. Mestern with with your defense expert report. And then if there's going to be the need to litigate the motion, obviously we may be able to do it on that particular day. We can always do a briefing schedule between now and then.
Works for me.
Perfect.
Mr. Mestern, anything further from the state?
Yeah, Your Honor, the state would ask for excludable time. It's a pretty long time between now and the next date, part of which is the outstanding motion filed by defense. So the state would ask for excludable time between now and then.
And the defense is requesting additional discovery. So counsel, any objection to excludable time?
Not from the defense, Judge.
No, Judge.
All right, so we'll note that excludable time will be entered between today's date, which is 2/24, and the next court date, which is 4/14. An order will be signed and entered to that effect, counsel.
Thank you, Judge.
All right, counsel, if that is all we have, then I'll excuse you all for today. Thank you very much.
Thank you, Judge.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
To me, please.
All right, very good.
Thanks, Judge. Bye,
Thank
Judge.
you.
You all may be excused.
Thank you, Your Honor. Judge, can we go off on a separate matter I wanted to touch base with you on?
Okay. All right. Enough of the fooling around. All right. Let me put myself back here. And now we will jump forward to the May 11th. This one I have not seen. I did watch that one now that I heard it. And I'm like, oh, wait a minute. We did watch that one. This one, however, we did not watch. So hopefully we won't have the camera operator going back and forth. All right, so this one is from May 11th. So this is just, about 8 days ago? So the 11th was like last Thursday, I think. Anyway, this is from May 11th.
Aye. Okay, counsel, let's go on the record now on the matter State, New Jersey versus Sean Higgins under docket 2412, 400 I. Counsel, your appearances, please.
Good afternoon, Your Honor. Michael Mestern appearing on behalf of the state.
Afternoon, Your Honor. Richard F. Kleinberg III, appearing on behalf of defendant Sean Higgins.
Thank you, Judge. For the record, it's Matthew Portella, co-counsel for Mr. Higgins, who's on my left.
Very good. Anyone else entering an appearance or just the two of you?
You want to enter your appearance? We'll put Yannick on today.
Good afternoon, Your Honor. Yannick Coles, Law Officer Matthew B. Portella, also on behalf of Mr. Higgins.
Thank you, counsel. All right, this matter is on for a pretrial conference as well as a motion filed by the defense to dismiss the indictment. I obviously received and reviewed the briefs, the reply briefs, and then the SIR reply briefs, as well as the SIR, I guess, reply response. I'll hear from the defense because it's their motion.
Thank you, Judge. Judge, rather than go for with what started way back when with the initial brief, I'm going to break down the argument as to essentially the last two briefs that have been filed here. And when you take everything in consideration based upon the pleadings, attachments presented by both the defense as well as the state, there's substantial proof that the state did not present the proper BAC evidence to the grand jury in a scientifically complete and non-misleading manner that would be consistent as required for grand jury jurisprudence. Now, I don't think anyone will dispute the fact that the test sample was documented as clotting. The toxicology worksheet indicated that the sample, quote, should be treated as a serum sample. Dr. Lage opined that serum alcohol concentrations are approximately 16% higher than a whole blood concentration. Yet, despite these scientific qualifications, the test results were presented to the grand jury as a definitive factual statement that the defendant's blood alcohol concentration was a 0.087%. Now, when this was instructed to the grand jury, the state said first that the intoxication could be established at a 0.08 BAC, and number two, that intoxication could support an inference of recklessness. And the sequential way that this is presented to the grand jury is important because the state, first of all, presented the value as a definitive whole blood BAC. Number two, never disclosed the clotting issue to the grand jury. Number three, did not disclose the serum treatment issue. Number four, did not disclose the need for the conversion methodology. Number five, did not explain any conversion factor. And number six, did not explain the scientific limitations or qualifications of the sample. Now, under both Hogan and Evans, the issue is not whether the state was obligated to present defense evidence, but whether the state presented a half-truth or distort a factual predicate material evidence that impaired the grand jury's ability to independently evaluate probable cause. Now, in the state's most recent filing, they claimed that the laboratory internally converted the serum value using a multiplier, but there's no indication that this actually occurred, nor that any such scientific explanation was presented to the grand jury itself. And Judge, what I'd like to point out is in the state's filing, if you look at their Exhibit A in the most recent filing, where they talk about the multiplier that was used, on Exhibit A for the laboratory report toxicology analysis, it just says item number one, blood, not analyzed, item number two, blood, and it breaks down the headspace as to the 0.087.
And Judge, that's on the May 6th submission by the state.
You there? Thank you, Judge. So when you look at that, it just says item number one, not analyzed, item number one, blood, not analyzed, item number two, blood, and it talks about the headspace analysis that was performed on September 4th. The issue we run into here when we're looking at what the state is now making its attorney argument as to the scientific reliability is between this exhibit and getting into the next exhibit, you note there's no breakdown as to what sample number it was, how we could connect what number one was as opposed to number two. And when we have a situation such as this, where there was already issues with the blood collection or storage, we're not sure what caused the clotting, it's an important factor to look at. So, I mean, I could look at this, or anyone could look at this and say, okay, we have item one, item two. Well, which one was item one? Which one was item two? There's no corresponding barcode number. There's no serial number. There's no evidentiary number. And this is difficult to ascertain. When you look at Exhibit B, then you have the breakdown of the toxicology worksheet, which, you know, reviewing this, Judge, I'm used to seeing this for drug cases, not so much with alcohol cases. But again, you can't link Exhibit A to Exhibit B and then to Exhibit C, because it just says item number one, blood, item number two, blood, and doesn't explain which is which one was the clotted one that was treated as serum, which one was treated as whole blood. So that is a major issue that I believe should have been properly explained to the grand jury when you have this type of breakdown. And the problem we run into now is it's almost 2 years later or 19 months later to go back in time and say, well, we used tube A, B, C, D for one, and it was E, F, G, H for two. We don't know that because that's not in the state's evidence. And I'm not sure why it wasn't properly labeled or marked, just as we're not sure as to why the blood was clotted, what caused that. But this omission is significant because the grand jury was not simply evaluating a raw toxicology data in a vacuum. The BAC evidence was firmly tied to statutory intoxication, recklessness, vehicular homicide, aggravated manslaughter, and from a forensic toxicology standpoint, serum plasma alcohol testing versus whole blood testing is a recognized scientific distinction. And again, the state says, well, we didn't have the defense report. How are we supposed to know to present this to the grand jury? That's not what the argument's about. The argument is the connection between the fact that something went wrong, something was improper with either the handling or the drawing of this blood that caused the clotting. And when it went to the forensic lab and there's an extra step that the state is now claiming was taken, there's no way we could tie that back to which sample was utilized. And when you look at the grand jury notes, which I believe the court has probably read through numerous times by this point, it specifically cited that the state presented the .087 as it were a direct whole blood statutory BAC measurement exceeding the legal threshold, when Dr. Lage opines that the actual threshold should have been lower than that. Based upon what you have limited in the vacuum that we have here, it seems that the materials that were presented to the grand jury were incomplete. If you look at the defense filings, and again, we don't need to go through it all, but there is the toxicology worksheet that we cited from the very beginning that says the sample was clotted and should be treated as a serum sample. The materials presently provided by the state, there still does not be any sort of disclosed laboratory report, toxicology report, worksheet, certification, or expert testimony that the laboratory actually performed the internal serum to blood conversion using the multiplier. And even if they said this is what happened, the problem we have, it doesn't tie back to Exhibit A. How do we know which tube of blood was tested in that manner? We don't know because there's no connection to it. We don't have a lab SOP setting forth how they went about it and why it's missing the breakdown as to the labeling. We don't have a chromatograph methodology report that independently says, yes, this is the one we used and it was done this way and we converted it this way. There's no validation study. There's no analyst certification. There's no machine calibration explanation. There's no toxicologist certification, nor is there a laboratory narrative report explaining what tube was tested at what time, and what was the reason for this different type of methodology that was used. The grand jury was simply told that the defendant's blood alcohol concentration was a 0.087%, without any explanation regarding serum testing, clotting, plasma equivalency, conversion methodology, or statistical limitations. The filings firmly suggest that the state's internal conversion explanation that arose during motion practice, and again, Judge, this is something that was brought up back in February. It was not until May 6th that the state says, oh, we did do an internal conversion. Here it is. Here's A, here's B, here's C. But there's no way of connecting A, B, and C. There's no way of showing that this was done in a scientifically acceptable manner. There's no calibration records regarding this. So it does take it a step further. And we have to remember the distinction here is that while Mr. Mestern can argue, well, yeah, we did it, and here are the exhibits. That's attorney argument. It's not evidence. It's not something factual. I can't cross-examine Mr. Mestern and say, how did you come up with this? Mr. Mestern, what's in tube 1 as opposed to tube 2? Can you give me that answer? It's impossible. We don't have any sort of, and I don't want to say independent, but a third party professional who says this is the reason why it was done this way, and this is the conversion that was used, and this is the proper method. It's been almost 19 months again, Judge, and we have no actual toxicology report, no lab methodology sheet, no machine-generated conversion record that shows this is the tube that was tested, that was the tube that was tested. We just have evidence 1, evidence 2, with no numbers corresponding it together, no expert certification. We have a foundation problem because there's no scientific basis for equating the reported value to a statutory whole blood BAC. And we have a grand jury distortion issue because of the state law documented conversion support at the time of presentment, which it seems that they did, then presenting the 0.087 as a statutory BAC is where it's either a half-truth or distortion. Again, I would not be standing up here making this argument if the state had, at the time of presenting the grand jury, the connection between what's in Exhibit A, and we had numbers that would match up to that, connect that to Exhibit B, and numbers that matched up to that, and connect that to Exhibit C, and they said this was a conversion where we converted plasma or clotting to whole blood, but that's not what happened. They said to the state, this is a statutory whole blood BAC. And the state can't say, well, we knew that at the time, because as Mr. Mestern admitted in his May 6th pleading, that's the first time the state brings it up and does that connection. There's no competent evidence yet produced showing that the laboratory internally converted the serum value using a validated multiplier, but there is unrefutable factual evidence that in the state's evidence that we have thus far, we don't have the connection between that Exhibit A, Exhibit B, and Exhibit C for us to logically be able to say, yes, what was presented to the grand jury was true in fact. Judge, I'm not asking you to throw this case out and for my client to walk free and be not guilty. I'm asking that the grand jury be presented with the proper evidence. This is not a huge chore on the part of the state. If the state says in their May 6th filing, yes, this is what occurred, then there's no harm in them representing to the grand jury saying there was an issue with the collection of blood. I don't think anyone's disputing that. There was an issue with the storage of blood. There was clotting. Because of the clotting, the clot had to be treated as serum. Because of that, an extra step was taken. This is showing why that extra step was taken. This is the conversion for the BAC that you have, not that it is a definitive whole blood sample. Thank you, Judge.
Mr. Kleinberg, just a quick question.
Yes.
And I understand your argument, and obviously from a practical standpoint, do you think it would not be better served at a 104 hearing where you actually have the chemist on the stand and you can cross-examine the chemist based upon his report?
Judge, you're either reading my mind or you look into my plans as to what this next step would be. If the court were to so deny this motion based upon this, the next part would be either a suppression motion as to the reading based upon the failed standards, the standards that were not properly met, or a 104 hearing as to whether or not it comes in. So yes, if the court were to deny it here, that would be the next step at that different standard of proof and argument where we would have testimonial evidence at that point. Yes.
Thank you. Mr. Mestrin?
Thank you, Your Honor. I just want to start off with where defense was. There was started off with the toxicology worksheet, and he kind of misquoted, which is what was misquoted in the lab report from their expert. I just want to put on the record what exactly was written on there. So it says the blood appears to be...
just for the record, that's Exhibit B, correct?
Correct, Your Honor.
Okay.
So its blood appears to be clotted, streaking to side of tube and not completely in solution, treated as serum for BAC. When counsel started his argument, he quoted it as saying, should be treated as serum for BAC. That's an important distinction. It does not say should be treated as BAC. It says treated as serum for BAC, which indicates that the chemist knew that he should treat this as serum to determine the BAC level for the blood collected in sample 2. Now, counsel indicates for a very long time that there's no way to connect Exhibit A, B, and C. A simple reading of the documents will connect them all together, Your Honor. First off, A is the report from the New Jersey State Police Forensics Lab. It says item 1 was not analyzed. And Your Honors, I know Your Honor's familiar with this case. You read the grand jury transcript that there was an initial taking of blood from the defendant. There was an issue with the seal from the tubes, so they did the second one. So that would be the first one. There was some issues that they did not test. Item number 2 is the blood that was taken, the second vial.
So, Mr. Mestrin, your position is on the Exhibit A, which is toxicology analysis.
Yes.
Where it says item 1, it says blood not analyzed. That was the tainted sample?
Correct, Your Honor. And this is all documented throughout discovery, what was and wasn't analyzed. So item 2 was actually analyzed, and it came back with a BAC of 0.087%. Now, the toxicology worksheet, Exhibit B, is the handwritten worksheet that all the chemists at the lab fill out when they're analyzing blood for either narcotics or for alcohol levels. And so the easy, simple reading of this will connect the two. If you look at the top right corner of the toxicology report, it says case number J260240359, number 2. If you go to the toxicology report, top right, it says laboratory number, and it's the same J number. And number 2 is in reference to the item number 2. So there is a way to connect all of these two. It's a simple reading of the document. Midway through, and where it says ethyl alcohol analysis, it has an A and B and has 2 readings. Your Honor, if you see that. A reading is 087 and the B reading is 088. That indicates it was tested twice. If you go to C, that is the printout from the testing equipment that tested the blood. At the bottom, it has those readings. And Your Honor, it has the sample multiplier that I indicated that they put in to make sure that it converted BAC from the serum levels that it was analyzed. So there is credible evidence to support the claim that there was a BAC level of 0.087%.
that was presented to the grand jury. There was no half-truths. There was no misleading or misdirection on the part of the state in presenting this case to the grand jury. All of these documents and more were presented to the defense in discovery. The defense's expert had an opportunity to review all of these documents and to make a thorough analysis of the case. However, he reads these. This is a simple case of a battle of the experts. It just goes to trial. There's nothing that requires the state to present any evidence regarding their experts' opinion on the matter. The way the documents all read is that the testing of the blood was sound and the results was 0.087%. And I'll just read onto the record, Your Honor, Supreme Court case real quick. It says the United States Supreme Court accurately characterizes the grand jury as an accusatory and not adjudicative body. A grand jury proceeding is not an adversary hearing in which the guilt or innocence of the accused is adjudicated. Thus, we decline to adopt any rule that would compel prosecutors generally to provide the grand jury with evidence on behalf of the accused. Such a rule would unduly alter the traditional function of the grand jury by changing the proceedings into an ex parte inquisite into a mini trial. The grand jury's role is not to weigh evidence presented by each party, but rather to investigate potential defendants and decide whether a criminal proceeding should be commenced. Credibility determinations and resolution of factual disputes are reserved almost exclusively for petit juries. That's what we have here, Your Honor. It's a credibility determination that petit juries are required to do. I was just quoting from State versus Hogan, 144. NJ 216, page 235. With that, Your Honor, there's no basis to dismiss this indictment. The indictment was thorough. It presented all the evidence clearly. The issues with the first vial of blood was presented to the grand juries. The blood was transported to the state police barracks for holding until it was transported to the lab. That was all documented in discovery, and that was also presented to the grand jury. So there's no basis to dismiss this indictment, Your Honor.
So, Mr. Messer, and I just want to refer you back to Exhibit C, where there's an indication, it says sample multiplier 0.862. Is that the multiplier you're referring to, which takes it from serum to whole blood?
It is, Your Honor, and it's an internal calculation with the testing equipment.
All right, thank you, Mr. Messer. Anything further?
If I may, Judge, just so I'm clear, I believe the state just said, so item number 1 from Exhibit A was not analyzed. Item number 2 was analyzed, and I think they said it was tested twice, correct? That's the state's argument. My issue comes with then, Judge, so it's we're clear, the state is saying that they test the same sample twice. If you go to Exhibit B, in the upper left-hand corner, it says number of tubes, 2, gray. Size, 10 milliliters each. Volume, one is 6 milliliters, the other is 4 milliliters. And then you have 2 different results there. It says 2 tubes were tested. State just said 1 tube was tested. That's been the problem I've been running into. If you look at Exhibit A, it says 1 tube was not analyzed. You go to Exhibit B, it says 2 tubes. And this is a problem because this is where it becomes problematic, where it's not just whether or not, hey, we only tested the one twice. We can't tell which was which, especially when it says Exhibit 1 says 1 not analyzed. Exhibit 2 has 2 separate tubes in it, and that's the problem. I can't differentiate. I'm not sure how the expert's going to be able to differentiate which one was actually tested between them.
And Mr. Kleinberg, if I'm not correct, when the state police do a blood draw for each sample, they take 2 separate tubes.
Right. But when you look at the sheet, we don't know which one was, because and then again, if this was a clean case where there was no issue, the problem we run into, it says blood appears to be clotted sticking to the side of tube and not completely in solution. Treat it as a serum for BAC. And the issue is which tube, and were both tubes tested. Based upon what we have, the argument still goes back to the reliability and what was presented. It's not, for whatever reason, this is not a clean, and what I mean by clean, I'm not saying state anything dirty. What I mean by clean is not one of the cases where you could just follow the line all the way through. It breaks up there, and therein lies the rub when it comes to the argument as to why this is something that should be represented. But if the honor is to say it's not at that level, then, as you brought up, most likely this will be a 104 hearing then, or a suppression hearing as to the admissibility.
And if I may, and I just want to get clarification, Exhibit A to Mr. Mestern's reply brief, Your Honor questioned him. They said, item 1, blood. Your Honor asked, is this the tainted sample? And the state said yes. So then item 2 is not the tainted sample, but was still treated as serum, which, again, there's confusion here. Why would it treat it as sample if item 2 was not the clotted blood?
I think I asked the question if item 1 was a sample they weren't able to use because it was tainted. Item sample number 2 was the blood that was actually viable to be used for the test, but the chemist says, at least my understanding is, it's clotted, so we need to treat it as serum.
So then is the state saying that both tubes were clotted?
That I don't know.
Okay.
We don't know either.
We don't know either.
Your Honor, it was treated, what they tested was treated as serum for BAC. The fact that there was 2 vials, every blood kit in the state of New Jersey has 2 vials. That kit is referred to in number 2. Number 1 was not analyzed. Those were 2 vials in that kit and they weren't analyzed. So what they tested as serum for BAC. There's no misdirection regardless of their confusion on what was or wasn't tested.
Judge, I guess then, I just asked, but was 1 tube clotted or 2 tubes clotted? That's all I need to know. I mean, I'm not asking for the meaning of life. It's a pretty basic question.
Again, this is a battle of the experts. It's not a basis to dismiss the indictment.
Even if it's not, Judge, for discovery purpose, then I'll place on the record right now, if you're not dismissing and for representing, I would like to know, was 1 tube clotted or 2 tubes clotted? Because if there's 2 tubes that are clotted, there's a serious issue then with the transportation or the storage of this blood for it to get to that point. So I need to know whether it's 1 tube clotted or 2 tubes clotted. I'm placing that request on the record then.
That's fine, Your Honor. Whatever tube was tested was clotted and treated for BAC. Whether there was 2 tubes or 1 tube, I'm not too sure of the relevance, despite what defense says. What is relevant is what was tested, the condition it was in when they tested it, and how they treated it.
And Mr. Messer, I take it you can obviously obtain that information from the state police chemist provided to the.
I can. I don't have the chemist right in my back pocket.
Of course you don't.
But yeah.
All right. Counsel, anything further on the motion?
No, Judge.
Thank you, counsel. With regard to the motion to dismiss, New Jersey law is clear that the grand jury's function is limited to determine whether there is probable cause to believe a crime has been committed and that the accused committed the crime. During grand jury proceedings, the prosecutor is obligated to present evidence that is clearly exculpatory and directly negates the guilt of the accused, but only if the prosecutor is aware of such evidence at the time of the grand jury presentment. And that's State v. Hogan 144 NJ 216 at pages 236 through 237, 1986, Supreme Court case. The grand jury process is not intended to be a mini trial, and the prosecutor's duty does not extend to presenting all evidence favorable to the defendant, only evidence that is both clearly exculpatory and known at the time. If exculpatory evidence is discovered after the grand jury has returned an indictment, New Jersey courts have consistently held that the state is not required to represent the case to the grand jury. The rationale is that the grand jury's role is limited to finding probable cause, not to determine guilt or innocence. Once an indictment is returned, the case moves to the trial phase.
where the defendant has the opportunity to present evidence and challenge the state's case. This principle is supported by multiple cases, which include State v. Hart, 139 NJ Super 591, Appellate Division 1976, State v. Smith, 296, New Jersey Super 297, Appellate Division 1993, as well as State v. Murphy, 110 NJ 20, 1988, all of which emphasize that the trial is the appropriate forum for resolving factual disputes arising from new evidence. The Appellate Division has reaffirmed this principle in State v. Hogan under 336 NJ Super 319, Aptiv 2001, as well as State versus Majewski, 450 NJ Super 353, Appellate Division 2017, holding that the prosecutor's obligation to present exculpatory evidence to the grand jury is limited to evidence that is clearly exculpatory and directly negates the accused's guilt, and only if the prosecutor is aware of such evidence at the time of the grand jury presentment. Requiring the state to represent the case every time new evidence is discovered would be impractical and contrary to the purposes of a grand jury proceeding. Our Supreme Court in State versus Saavedra 222 NJ 39 2015 further emphasized that the grand jury process is not a substitute for a trial, and that the prosecutor's duty is not to present all favorable evidence, but only that which is clearly exculpatory and known at the time. Policy considerations also support this approach. Requiring the state to represent every case to the grand jury upon discovery of new evidence would undermine the efficiency and finality of indictments. The jury at trial is the ultimate fact finder and is the best positioned party to weigh conflicting evidence, including expert testimony regarding BAC levels. The defendant is not prejudiced by this process, as they retain the right to present new evidence at trial and argue for acquittal. Applying these principles to this case, the defense's expert BAC evidence was not available to the state at the time of the grand jury presentment. Under our law, the state is not required to represent the case or seek a superseding indictment. The defense can and should be able to present this evidence at trial, where the jury will decide whether the BAC was below the legal limit and whether the defendant is guilty. Our law is clear that the state is not required to represent an indictment to the grand jury based on exculpatory evidence discovered after the indictment. The issues for the jury at trial and the defendant's remedy is to present the evidence at trial, not to seek a dismissal of the indictment. And when I'm reviewing, obviously, the grand jury transcript, I did not see anything in the grand jury transcript whereby the state attempted to intentionally mislead the grand jurors by presenting either half-truths or evidence that was not clear. When the evidence was presented to the grand jury, it was presented in such a manner that was direct, and obviously the testimony at the grand jury regarding the blood alcohol readings was clear and concise. There was no indication that the state was trying to fabricate evidence or place evidence in before the grand jury that it was not appropriate. Obviously, it's brought to the state's attention by way of the defense's motion that there is a potential issue at the BAC level regarding whether the blood was analyzed for serum purposes or whole blood purposes. The state contends that their expert considered it as blood serum for the purposes of BAC, and obviously that would be an argument which is more for a finder of fact than it is for a decision maker regarding whether a motion to dismiss should be granted. That issue can either be raised, as Mr. Kleinberger indicated, by a motion to suppress or through a 104 hearing prior to trial. Obviously, at a suppression hearing, it'd be testimonial, and the state would have to call the chemist to testify, and the defense would obviously be able to get some clarity as to whether or not both vials were clotted. But at this juncture, the court finds that the evidence was presented to the grand jury was adequate, and that there was no basis at this time to ask the state to represent, or is there any basis to grant the motion to suppress. So for those reasons, I'm denying the motion, and we were going to relist this matter for a hearing, or actually for another PTC on 6/16. Obviously, if it's the defense's intent to file a motion to suppress, you can file that motion and we'll do a briefing schedule.
Judge, it's going to depend upon when we receive clarification from the state as to whether both tubes were clotted or only one. It's impossible to tell by Exhibit B. It just says there's two tubes listed and it says clotted. So we're not sure which was or which was. So I just need to know that.
So under the circumstances, the state can provide some clarity to the defense before our next court date, which is June 16th.
Yes.
2:30, Judge?
2:30.
Judge, I could follow up with Mr. Mestern with a letter outlining what it is that we're looking for.
Please.
I could do that.
Mr. Mestern.
Your Honor, yeah, I like I said, I should be able to get regarding what tube was or wasn't tested out to defense counsel by the end of the week. So if they want to file a motion to suppress, we should be able to get that taken care of and move forward with that. Hopefully, if not on the next day, get a briefing schedule quickly so we can kind of move it along.
And obviously, you need to check on availability of any witnesses they may have to call.
Correct, yeah, and just see what the arguments are. Yeah.
All right. Counsel, anything further?
No, Judge. No, Judge, thanks.
We'll serve notice for the new court date, and once we do that, we are adjourned for the afternoon. Thank you.
Thank you, Judge.
All right. All right, counsel, that'll be in courtroom B304.
Here, right?
Here.
B.
All right, so let me, I had not seen that before. I had not seen that one before, so that's good to hear all of that. So the defense is saying, so it all boiled down to Sean Higgins was tested by state police, and they took 2 samples, and one of them, the report read, blood appears to be clotted and sticking to the side of the tube and not completely in solution, treated as a serum for BAC. So the defense is saying, we don't know which one. Were both tubes tainted? Which one did they test? And I guess apparently serum tests higher, or plasma will test 16% higher than whole blood. So then the state's saying, well, if that's the serum, then he would have tested. So if the serum is coming back as 0.087, then the whole blood would be 0.75, I think. It would have been less. So they're fighting very hard for it, and I don't fault them for fighting for that. Penalties are definitely significantly higher if you've been drinking and you're involved in a deadly car accident. It would probably just, I hate to say just, it would be vehicular manslaughter versus, DUI, death involved. I mean, it's, and then aggravating factors, it would be definitely significantly higher. I don't know, maybe it'd only be 10 years instead of he's facing 35 years or 70 years, that kind of stuff. So that's why they're really fighting. Defense is really fighting for it. And then ultimately the judge denies the motion to dismiss. So yeah, Heidi, that's really interesting. 0.05. So we're 0.08, which I think is like a beer an hour. I think that's what they say. It's been a long time, but how much beer is 0.08? It comes up. I didn't search for that before. All right. Oh, it takes 3 to 4 standard beers consumed in an hour to reach 0.08. All right. So I've heard way back in the day where they said if you drink a beer an hour, you should be okay, because you absorb, again, depending on how heavy you are, how used to it you are. But 3 to 4 standard beers will get you 0.08. So yeah, beer and a half is let's see what's 0.05. What's 0.05? 1 to 3 standard beers, depending on your weight, gender, how fast you drink it. So here's the 1 drink rule. For most people, consuming 1 standard drink per hour is the general rule of thumb to stay safely at or below 0.085. So there you go. So you guys, yeah, you're a beer an hour. So that's what I've always known. Michael says that is what the defense is saying, but that is not reality. The lab tech would have put serum into the sample type, and the instrument automatically calculates the value. Yeah, I didn't read that part where the chemist, the defense. I'm sorry, the state was saying the report reads, treated as serum for BAC. The chemist knew to treat this as serum. So the defense is saying one thing, and yeah, you're right. The state is saying, well, no, the chemist knew to treat it as such. So, and then ultimately, Heidi, yeah, just stay sober. Just stay sober. Exactly. So, play on crime. What are you doing in court? Yes, you went back and you saw that. That's funny. Richard, it takes time after consumption to enter the bloodstream. The liver can metabolize 12 ounces in 1 hour. 80s Music Man, good to see you. Skrubnik, yeah. And, again, don't drink and drive. Just bottom line. I mean, if you have to have a drink, make sure you drink a lot of water, give yourself at least an hour. And even then, just call an Uber. It just doesn't make sense. Not anymore. It just doesn't make sense to do it. So anyway, don't take my advice. Just don't drink and drive. Simple as that. Because even if you drink and then you drink water and you wait an hour, you could still have a headache. Your reaction times would still be slow. I would just say, just don't do it. It's just not worth it. Play on crime. Sorry, you're behind. You're sitting amongst the other Zoomers. Yes. Yes. Hola. All right, you guys. We're going to end here. I've got I have a portal set up. We're going to be meeting with Clairview in 25 minutes. Let me post this for you guys. This is our recap. What did you call it? Our recap and reaction to recaption. What did you call it? Paul Canero recaption. Reaction recap with Claire at 4 p.m. So that's coming up in just a little bit. So coming up, there is the. If you want to wait for the portal, I have a redirect on. If you don't, then just grab it. Recaption. Okay, that's what I thought. Yes, the recaption. All right. So the reaction recap, the recap reaction, the recaption. All right. So there, if you want to click on that, you'll be taken over. And if you don't, do you want to just hang out? We'll portal you over, and we will see you guys in just a little bit. So I'm just going to take a quick break. And we will see you in 20 minutes or so. Thank you for joining us for this update on Sean Higgins, New Jersey versus Sean Higgins. And thank you to our mods. Thank you to Aaron. And we will see you guys over at Paul Canero in just a little bit. So until then, take care and we'll see you. Bye.